5 seconds to go. Start. It was urged that there is discrepancy in the testimonies of various witnesses, particularly that of PW1, father of the deceased, and the others, particularly PW4 and PW5, as to whether the suspicion of the accused's involvement was, in fact, reported within a couple of days after the boys' bodies was found. Counsel especially highlighted that the police witnesses did not support the version of PW1 that he had voiced suspicions contemporaneously. Further, it was submitted that the testimonies of witnesses were that the accused's role was not known to PW1 and others on 10th October 1999, but this was not reflected in the inquest report. Learned counsel submitted that the prosecution witnesses are untrustworthy since they appear to have been added as afterthoughts. It was submitted that the appellant's consistent case was that they were named much after the incident on account of enmity with the deceased father's family. It was pointed out that in the testimony of the first IO PW8 that PW2 did not mention about the role and involvement of A3 and that she was with the deceased on 8th October 1999. Further, that witness PW8 also testified that the villagers had initially suspected Salim and Mansoor and not the present accused. Learned counsel highlighted that P4 and PW5 are wholly unreliable witnesses. In fact, the police statement of PW4 was recorded much after the incident in December 1999. This witness, as indeed PW5, were introduced to somehow implicate the first two appellants A1 and A2, since there was no other witness who supported the prosecution with respect to their alleged involvement or presence. The idea of introducing them was to link them with the deceased. It was submitted that PW4's testimony was unreliable because he recorded his police statement after 2 months and, as per his admission, though he had seen the deceased in the first two appellants' company and informed PW1 about this as early as on 12th October 1999. Likewise, PW5 deposed having informed PW1 on 12th October 1999 about witnessing the boy in the company of the first two appellants on 9th October 1999. No explanation was given by the prosecution why he was examined so late. Furthermore, the deceased father PW1 did not mention having been told about the involvement of the first two appellants by PW5 in his written complaint. It is argued that the last seen theory is, on the face of it, an afterthought and concocted inasmuch as PW7 stated before the court that PW2, PW3, and PW4, who all were closely related to the deceased child, were present at the time of inquest proceedings held on 10th October 1999, yet they, for the reasons best known to them, kept silent for 2 days and for the first time informed PW1 only on 12th October 1999. Yet that witness PW1 did not mention these facts in his written version. It was contended that all prosecution witnesses were of the same family as complainant PW1 is the nephew of PW2, PW3 is son of Sharif, PW1's cousin, and PW4 as well as PW5 too belong to PW1's family. It was urged that there was reason for the witnesses to cook up a false story against the appellants because in the year 1996, father of the appellants had lodged an FIR against PW2 under section 307, 452, 504, 506 IPC and they were prosecuted. This clearly established their motive to falsely implicate the appellants. Counsel highlighted that according to PW7 deposition, who was a witness to establish the inquest report, they were also present at the time of inquest. It is unimaginable that had they seen the deceased in the company of accused persons, they would not disclose the same even after seeing the dead body of their kith and kin. This incongruity went to the root of their credibility, falsifying the prosecution version. Learned Counsel relied on Hanumant versus the state of Madhya Pradesh to contend that in circumstantial evidence based case, each incrementing circumstance must be clearly established by reliable and clinching evidence, and the circumstances proved must form a chain of events from which the irresistible conclusion of the accused's guilt can be safely drawn. No other hypothesis is possible. It was submitted that this court has cautioned that in a case depending upon circumstantial evidence, there is a danger that conjecture or suspicion may take the place of legal proof. The court must satisfy itself that various circumstances in the chain of events have been established clearly, and such a completed chain of events must be such as to rule out a reasonable likelihood of the innocence of the accused. Stop.